I made an offer on a property. The sellers came back to me and said, hey, we're actually having our realtor friend help us out. They accepted my offer. The broker sent me a contract. It was not really that great, to be honest with you. So I said, hey, I really appreciate this short contract, but here are 13 edits that I need to feel comfortable as a buyer. So this is the contract that my attorneys produced for me. I'm in the process of reviewing this contract, and then I'm going to send it back to the seller on this deal, and hopefully they say yes. So none of this is legal advice. Let's look at what a good real estate contract looks like, okay? So real estate purchase agreement, sometimes this is called a PSA, purchase and sales agreement, is what you'll see it sometimes. So let's read through this purchase agreement and all the exhibits. We'll talk about that. Here and referred to as the agreement is made as of this day of this month in 2023 between blank, which this is the seller. So I'm just trying to be, all good here with people's privacy, the seller's privacy. So I blacked out a couple of these things, but this would be between the seller, which is an LLC, a Georgia limited liability company, which they're going to call the seller from now on, and Crabtree Capital LLC, a Georgia limited liability company. That is my LLC that I use, but I'll get into something else here in a second to talk to you guys. In consideration of the following terms, conditions, covenants, and restrictions hereinafter set forth, buyer and seller agree to the following. So it's just saying, hey, we're going to agree to the following. So we're going to agree to number 1. We're going to agree to number 2. We're going to agree all the way down, guys, to number... If we look through, we really have 12 main points. Now, within each of the points is going to be subpoints. So we have, as in number 1, these are the things I'm getting included in this purchase. So we have 1 as a category, and then we have these different things that I'm going to get in the purchase. So let's read through. So seller will sell, assign, transfer, and convey to the buyer, and the buyer will hereby purchase and acquire from the selling the following things. This is all the stuff that I'm buying in here. Number 1, the real property located at, here's the address in Georgia, and this is shown as Exhibit A1. Now, what is an exhibit? An exhibit is what gets attached at the end of the contract. Instead of having to detail every single thing here about what is this property, the attorneys, they just say, hey, check Exhibit A1 for more detail on this, right? It's kind of like when you're reading a book and it's got like a little star by it, and it's like, see glossary for definitions. So you flip to the glossary and it has half a page about what that thing with the star is. That's kind of what this is. That's what exhibits are. So it's going to be Exhibit A1, which is attached, and being more particularly described on Exhibit A2. Now, what does that mean? A1 is a map of the property. A2 is a legal description of the property. So that's why they include both of those. Together with all improvements, so a building is called an improvement, or a sign is called an improvement, or asphalt is called an improvement, as well as any rights, privileges, and easements appurtenant, which to me means relevant. I really don't know what that word means, but I don't worry about every single word in here. Belonging to the real property, as well as all development rights, air rights, water rights relating to the properties, utility agreements, meaning our relationship with the power company, the water company, and any easements, right-of-ways, and other appurtenances used in connection with the beneficial use and enjoyment of the real property. Collectively, all of this is called the real property, okay? So pretty much just says we're buying the property, all the buildings, and all the agreements that comes along with this property. Then the second thing I'm going to get is the right, title, and interest in those certain leases described. Sorry, it's been a long day. On Exhibit B1. So again, all the leases I'm going to buy, and I'm going to get access to all the leases, which will be shown in Exhibit B1. Collectively, the leases, okay? And any guarantees. So if the tenant's guaranteed the current landlord, those guarantees will transfer to me. 1.3, those certain items of personal property located on the real property which are owned by the seller, included without limitation those described in Exhibit C. So in Exhibit C, it's going to say things like this is a mini storage facility. So am I getting their golf cart? Am I getting their computer in their office? They have a bunch of locks. Am I buying all of those locks from them? That is the personal property. Personal property is the things that are not attached, okay? Now 1.4, seller's rights, title, and interest to any assignable licenses, government approvals, permits, and certificates of occupancies. So they were going to build some extra RV canopy VIP storage is here. They said they already applied for it. So I want to buy those permits from them so that if I want to build them, I can do so. That's what 1.4 is. 1.5, seller's right, title, and interest to any assignable warranties and guarantees that the seller has received. So for example, they just put in a new AC unit. If the AC unit there had a 5-year warranty from the company that put it in, I now own that 5-year warranty. Okay, number 1.6, I'm going to buy the rights to the copies of all initial and supplemental surveys, plans, specifications, architectural and engineering drawings, owner manuals covering the real property. You know, we all know what this means. All right, all the intangible property. Okay, so all the intangible property and rights associated with the land and improvements, including without limitation, email addresses, phone numbers, fax numbers, property identifier names, I don't know what that is, and all rights in and to the name blank self-storage. So currently, this is called Billy Bob self-storage. That's not really what it's called, but it's called something. Again, for privacy, I'm not going to tell you what it is, but I am buying the rights to the name, and all of these things, along with the phone number, the email, those are called the intangibles. I am buying those in this purchase. And then we're going to have all the items referred to in section 1.1 and 1.7 are here collectively referred to as the property. So anytime the rest of this contract that we see the word property, it's referring to all of these things. Okay? That's point one. Point number two, and I'm going to try to move faster than this. The purchase price. I'm going to buy this for $2,250,000. Let's talk about that. Within 3 days of the execution of this agreement, the deposit in escrow, the earnest money, me, Hayden, am going to give the escrow agent, which I'm not going to list the escrow agent's name, but this is the name of the person I'm going to give it to, which is involved in the transaction. Usually it's either the closing attorney, the title company, or maybe the realtor broker involved, okay? A deposit in the amount of $40,000. So I'm going to give them $40,000. At closing, and then we're going to get into sub 2.1. Now we're at 2.1.1, so we're going to go into more detail on 2.1. At closing, and if the sale and assignment of this property is contemplated hereunder is consummated, you know what consummation is? Means you complete something, right? The earnest money deposit shall be paid to the seller and credited against the purchase price. What that means is this $40,000 is going to stay with them at closing. They're just going to give this $40,000 they're holding on to the closing company, and that's going to go towards part of my down payment in the property. That's all it's stating. If closing does not occur solely because of material default or failure to perform under this agreement as part of the buyer, me, so if I fail, the seller, the person selling the property, shall retain the earnest money deposit as the seller's sole and exclusive right to damages and other remedies at law or in equity. So what this means, guys, is if I fail, particularly after my due diligence, which we'll talk about that here in a second in the contract, if I fail to purchase this, then the seller gets to keep my $40,000 and the property. So I want to make sure I don't fail because I don't like losing $40,000 and not getting anything out of it. That's what this says, which it's fair and that's standard, okay? I'm tying the property up with the seller. They can't sell it to anybody else. If I fail and waste their time, they should get some sort of compensation for that, okay? The parties have agreed the seller's actual damages upon default by buyer would be extremely difficult to or impractical to determine. Accordingly, buyer and seller agree that the earnest money deposit represents a fair and equitable payment for liquidated damages. The payment to the seller of the earnest money deposit as liquidated damages is not intended as a forfeiture or penalty within the meaning of the applicable law and is intended to settle all issues and questions about the amount of damages suffered by the seller in the event of default. So what that's saying is that if I fail, they get the money and they really don't get to ever say, hey, you caused us this pain or this pain, give us more money. That's all you can do, okay? Upon the breach by seller of any representations of warranties contained in this agreement or the default by seller in the performance of any other obligation of seller set forth in this agreement, the buyer, Hayden, may seek to specifically enforce performance of the seller's obligations under this agreement. This is called specific performance. It means if you tell me you're going to sell the property, I go get a survey, I line my banker up, I spend my time on it, you don't sell me the property, I'm going to sue you for specific performance. It means I'm going to sue you to specifically perform what you agreed to, aka sell me the property for $2,250,000. Okay? Or I can do this, or I can terminate this agreement by written by delivering a written notice, so I just tell them in writing, I cancel this agreement, in which event the earnest money shall be immediately returned to the buyer, and the buyer shall be entitled to recover from seller's buyer's actual out-of-pocket costs in connection with this agreement, including without limitation cost of attorney's fees, engineer's fees, consulting fees. So effectively, you're going to give me my earnest money back, and I'm going to send you the bill for all the money that I spent, and you're going to pay for that. Okay, let's move on to 2.2. So we're still talking about the purchase price now. The balance of the purchase price shall be paid by the seller by federal wire transfer and readily available funds on the day of closing. So this just says the day of closing, I'll deliver the rest of the money, $2,210,000. Okay. The escrow agent will deposit the earnest money deposit in a non-interest bearing account and shall hold, refund, disperse, and or distribute, as the case may be, the earnest money deposit in accordance with the terms hereof. Seller and buyer may jointly and severally agree to hold escrow agent harmless within respect to the performance of the duties of the escrow agent. Not much there. If any dispute arise between the buyer and seller as to the final disposition of the earnest money or any part thereof, the escrow agent may notify each party that the escrow agent is unable to resolve the dispute, and the escrow agent may but shall not be required to interplead the earnest money deposit into a court of law. So all we're talking about here, guys, is if at the end of the day we have a disagreement, whatever happens, the roof needs a lot of work, I say I deserve my earnest money back, they say no, the earnest money agent may say, hey, listen, you guys disagree, I can't send the earnest money one way or another, here's what we're going to do. That's what this is telling us right here. Let's talk about number 3, survey and title of the property. So buyer, Hayden, at Hayden's expense, shall have the right to cause a surveyor license in the state of Georgia to prepare a ALTA survey, which is a standard survey of the real property. So I have the right to do that at my own cost. Buyer shall have the right to obtain an ALTA title commitment issued by the title company acceptable to the buyer. So I can go get a title commitment for this, for an owner's title insurance policy in the amount of the purchase price, blah, blah, blah. Seller shall have until the end of the due diligence period to review the survey and or the title commitments and deliver seller a title objection notice and or a survey objection notice. Any title or survey defects shall be shown on title commitments or survey to which the buyer does not deem to be permitted exceptions. Buyer shall pay for all costs of the title insurance premium and any ALTA endorsements required by buyer or its lender, and the cost associated with the title update of the real property charged by the title company at closing. Buyer shall be responsible for all costs and expenses in connection with the title commitment and examination. So these are part of our closing costs. It's outlaid right here that I will pay for the title insurance and I will pay for the cost of the title work. That's what this is saying right here. And this is saying right here, guys, if there's a title objection, for example, we find that there's a lien on the property, a bank loan on the property from 15 years ago, I can issue a title objection. That's what this title objection is. And the seller shall have until the date that is 2 days before closing to cure the objection. So to go to the lender and to say, hey, you guys have this lien, what's this about, remove it, or pay the loan off, or whatever it is. So that's what this right here is saying. 3.4, at the closing, the seller shall convey to buyer good and marketable and insurable fee simple title to the real estate. So effectively at closing, they're going to give me all rights along with the property, along with a limited warranty deed in a recordable form. If requested by buyer, by me, seller shall also to deliver buyer a quitclaim deed conveying the real property by the legal description reflected on the survey. So I'm going to get a deed. I could get it by quitclaim or I could get it by limited warranty deed. Notwithstanding any provision here to the contrary, any mortgage, security deed, lien judgment, or other claim in a liquidated amount which constitutes an exception to the title of the property shall not in any event be a permitted exception hereunder, but such claim shall be paid, bonded, or insured over in full by seller. So all this is saying is if there's a lien on the property, the seller will take care of it, okay? The seller shall not encumber the property in any manner prior to closing, nor shall seller knowingly permit the property be so encumbered. So effectively all this is saying, guys, is the seller can't go do something that would prohibit the property from being sold, like going and putting a lien on it or something like that. Seller can't do that during the contract. So that's number 3. Let's move on to number 4, due diligence. Buyer, Hayden, and his employees, agents, or designees at my sole expense shall have until 5 p.m. on the day that is 60 calendar days after the effective date. The effective date is the day we both signed. So if I sign this on January 1st, I have 60 days after January 1st to do my due diligence, to examine and test the property. During such due diligence period, buyer shall have the right of ingress and egress, that means to come on and to go off, over and through the property for the purpose of inspecting, appraising, soil and environmental testing, testing for drainage, surveying, preparing engineering, architectural drawings, or any other activities reasonably necessary to assess the property, including the review of the title of the property as set forth in Section 3. So all this is saying is I can access the property to do whatever I want to make sure I want to buy it, okay? Buyer shall indemnify and hold harmless seller from and against any and all expenses, claims, losses arising from the connection of the activities of buyer. So this is just saying, if I pay a contractor to go out there and it costs me money, I shall hold the seller harmless for that, okay? It's officers, agents, employees, contractors, including without limitation, any reasonable attorney's fees and court costs occasioned by such claim. However, the foregoing indemnity and hold harmless obligations do not apply if any loss, liability, cost, or expense arising from or related to the acts or omissions of the seller or its agents or consultants, to the extent that such acts or omissions are not directly resulting from buyer's breach. So again, earlier we said if they breach, they're going to pay us back. This is just clarifying that that is still in fact true. Or number 2, any diminution in value of the property arising from or relating to the matters discovered by buyer during the due diligence period, any defects in the property discovered by buyer during the due diligence period, the release or spread of any hazardous substances which are discovered but not deposited on or under the real property by buyer. Seller and buyer agree that during the due diligence period, buyer shall have the right to terminate this contract to be exercised, meaning to be done, in the buyer's sole and absolute discretion, by delivering to the seller and escrow agent written notice of its termination, the termination notice, no later than the expiration of this due diligence period. Guys, you always want to make sure you have this in your contract. Huge that you want to explicitly state that I can cancel the contract for whatever reason I want in the due diligence period. The seller and buyer hereby agree that in the event of a termination of this contract, pursuant to the terms of this paragraph, the escrow agent shall promptly deliver to buyer the earnest money deposit upon receipt of a copy of the buyer's termination notice. This is huge. If I go and I do due diligence on this property, I can cancel anytime in the due diligence and immediately receive my earnest money, my $40,000 back, as long as I cancel in my sole and absolute discretion on this property within the first 60 days. Huge. Number 5, seller due diligence deliveries. So these are all the things that I want the seller to give me, and it states when I want him to give them to me so that I can do proper due diligence on the property. So right here it says within 5 days of the effective date, within 5 days of signing this contract, the seller shall give to me, the buyer, all of these items: all the leases, amendments, guarantees from the tenants, a copy of the most recent title policy, so I can see all the easements on there, a copy of the certified survey of the property showing all the improvements if they have one, copies of all material notices and certificates received, any environmental or geotechnical reports on the property, copies of all issued building permits and plans that have been submitted for building permits, any other existing reports, permits, warranties, contracts for the property, historical month-by-month P&L statements. I want their profit and losses month by month. Copies of all plans approved by the seller or any tenants for improving the property. Copies of financial statements for the tenants or any guarantors of the leases. A management summary report and concurrent accounts receivable for the lease, together with operating statements, common area maintenance info, and loss runs. Copies of the plans in seller's possession, including the site plans and construction plans. Copies of the service agreements and warranties affecting the real property. Any documents reasonably requested by buyer, so anything that I reasonably request by the buyer, if any, in the seller's possession, okay? In addition to the above, the seller shall provide to buyer, the seller of the property shall provide to Hayden, an updated management summary report and an updated rent roll every 30 days following the effective date. Very important for me that I'm going to have 60 days of due diligence. That'll be 2 times that they send me an updated rent roll, a management summary report, so I can see how the property is doing through the process. If they quit managing it the day we go under contract, I'll notice because the income, revenue, and amount of tenants will start to go down. So let's move over to number 6, the closing. All this is just going to talk about the closing, what the sellers are going to give me at closing. This is a lot of legal mumbo jumbo, just saying everything they're going to give me at closing, from tenant notice letters, lien waivers, bill of sale, closing warranty deed, closing statements. Not super crucial here. You can pause and read through this if you want. They'll also assign the leases to me. Yeah, so here's an important one. Unless paid directly by the tenants, which it's not in this case, to the taxing authority for the current year, the taxes, real property taxes, the property taxes shall be prorated between buyer and seller on the closing statement based on the most recent information available as of the closing date. Any rents paid or payable under the lease for the month of the closing shall also be prorated between the buyer and seller. Security deposits under the lease, if any, shall be credited to the buyer at closing, or at buyer's option, buyer shall receive a separate check or wire from seller at closing in such amount. So what does this say? If I buy the property halfway through the year and there's a $20,000 tax bill, I don't want to pay all $20,000. I didn't own it for all of the year. I owned it for half the year. I only want to pay $10,000. So the seller is going to give me $10,000 so that whenever I have to pay the $20,000 tax bill, I'm only paying my fair share. Same for rents and income. If I'm buying a property halfway through the month and there's $20,000 worth of income on that property, well, the seller owned it for half the month. I own it for half the month. I want my 15 days worth of rent. I want my $10,000 worth of rent. That's all this is saying. If there's any security deposits, they'll transfer those over to me. That's everything that it's saying here. Okay? All this is pretty standard stuff. Seller shall pay any water, sewer, utility charges through the day before closing. All of the other income and expense shall be prorated. With any respect to any prorations made at closing, shall belong to buyer. Seller shall pay or be charged recording or filing fees. Buyer shall pay or be charged the cost of the owner's premium for the title policy insurance. I'll also pay the cost of recording the deed. I'll also pay the cost of any survey, inspections, or investigations, and the fees and expenses of the buyer's attorney. Seller shall pay seller's attorney, transfer taxes, brokerage fees, dues, filing fees. Here's everything I'm going to. So this is outlaying our closing costs. Who's going to pay what closing costs? Any other closing costs and fees to be paid shall specifically be described above, shall be paid in by such parties customary as real estate closing in Athens, Clarke County, Georgia. I need to talk to my attorney about this because this is not in Athens, Clarke County, Georgia. So I'll highlight this. Representations and warranties. So reps and warranties, just like, hey, the seller, I'm representing and I'm warranting that there are no condemnations. There are no environmental or zoning or land use regulation issues. I'll warrant that there's no hazardous and toxic waste substances on the property. I will warrant and rep that the documents delivered, we have the full legal ability to deliver these documents, right? The leases that have not been amended, except in B1, are in full force and effect. These are all the things that they're representing and warranting, which are pretty standard, but sometimes you just want to list these. I'll represent and warrant that there are no current pending or threatened litigations for the property. I'll warrant and represent there are no outstanding leasing commissions to brokers. I will warrant and represent that we have no notice of violation of any document of record. I'll represent and warrant that we're not in any management agreements, service contracts, or third parties that may otherwise affect the closing. Right? These are all warranties and representations of the seller. Here are the warranties and representations of me, the buyer. I will warrant and rep that all docs executed by me shall be, that I'm pretty much approved to do so, and I will represent and warrant that these documents shall survive the closing and shall not be deemed to have merged into or governed by the closing date for a period of 12 months. Just legal stuff, right? Conditions precedent to closing. That seller shall not have breached any of its reps and warranties, that the title condition shall be selected, that I can get the title company to give me a title commitment. The seller shall have delivered to buyer all the items required, like the due diligence, all of those. There's no material change. All other conditions precedent to consummate the transaction are set forth in this agreement. Let's see here. In the event that any of the conditions precedent have not been fulfilled on the closing date, buyer shall have the right and its option to waive the unsatisfied conditions, to terminate this agreement by delivery of written notice to the seller in which the earnest money shall be immediately returned. So this is just saying that what happens if these conditions to close have not been met. what can happen. I can cancel the contract, get my earnest money back, or I can just accept it as is. The obligation of the seller to close under this agreement is subject to the following. The buyer shall have paid the purchase price in the manner provided in this agreement, and the buyer shall have delivered to seller all of the items required to be delivered to seller by buyer or buyer's agent. Okay? Makes pretty good sense. Number 10, MISC. If we have to give out notices, where are we sending those to? This is their name. We need their address and their email so I can send them notices. And same, I would fill in my name, my address, and I would fill in as well my email here with a copy to, and this is the attorneys, so I want to block them out. Brokers and finder's fee. Neither party had any brokers or finder's fee except for this person. The effective date is the date in which the buyer and seller last signed this agreement. The assignment, successors, and amendments. This agreement shall be binding upon, right? So I'm going to assign this. I'm not actually going to buy this property in Crabtree Capital LLC. I'm going to buy this. I'm going to go create an LLC just for this property, and I'm going to sign the contract. It's currently in Crabtree Capital. I'm going to give the rights to this contract to the new LLC because I just have an LLC on every single property. So this is saying here that that I'm allowed to assign it. Buyer may freely assign all or any portion of this agreement without the seller's consent, provided that buyer shall not be relieved or released from the obligations under this agreement. So pretty much I can assign this, but if I assign it to a new company, I'm still liable to make sure that the company follows through, right? That's fair. Governing law and merger, we're just going to do this in the state of Georgia. Enforcement, which is just saying if either parties fail, here's how we're going to enforce this thing. Document execution, it's understood that that this agreement is not final until the documents are executed. This agreement shall not be construed in the favor of either party. The interpretation, the counterparts. If I sign one, they sign another. Those are what counterparts are. Final dates, just talking about Saturdays, Sundays, weekends, holidays, captions. 1031 exchange. If the buyer and the seller want to use a 1031 exchange, we're pretty much giving each other the right to do that because you have to sign off on a little paperwork. Doesn't really impact anything. We're just saying we agree to it. Casualty, loss, and condemnation. So if the government comes and condemns the property, tornado comes through and wipes it out, this is just saying what happens in those crazy cases, okay? Here's where the seller would sign. Here's where I would sign if I agree to it. And then down through here, this is the real property description. It's got an image of the property, layout of the property. This is where the legal description of the property will go, which my attorney will insert. We'll insert all the leases inside of here. We'll insert the rent roll inside of here in the exhibit. And then we'll list the list of personal properties I'll get here inside of Exhibit C. And guys, that is how you read through a contract. Now, I could have gone into more detail. I didn't want to bore you. I just want to show you the high level and just read through it and look up words that you don't know what it means. And don't be afraid to ask an attorney or whoever wrote the contract, hey, what does this mean? If you have any specific questions about reading contracts, drop me a comment below. And if you made it this far, I know you liked the video. Who's gonna watch a YouTube video of somebody reading a real estate contract if you didn't like it? So do me a favor, hit that like button, subscribe to the channel, share this with a friend, a partner who may need to learn how to read real estate contracts and what it means. I hope you guys found this valuable. I'll see you in the next video. Be great.